In this short video, we're going to look at an evaluation essay on murder. Evaluation essays appear on exam 3. The question is, the need to update the common law offence of murder is as strong as ever if the law is to serve defendants, victims and society well. Discuss the extent to which this statement is accurate. As usual, that's worth 25 marks and you would have 45 minutes to answer it. I've included this image to remind us of the Law Commission's criticisms of murder. They describe the law on murder as a mess and being built on shaky foundations. And that's a reminder of what we really need to be looking at in this essay. So if we scroll down to my suggested answer, as usual, my AO1 comments are in black font, my AO2 comments are in red font. It's really important that you don't just write all about murder and causation, because you only get 10 marks for AO1, 15 marks for AO2. So you need to concentrate on evaluating the law on murder. So in my introduction, I've started off by saying that despite the fact that murder is the most heinous or the most serious crime we've got, it's quite surprising that our definition comes from a 17th century judge, Lord Coke, and that the legislature hasn't been involved on the law on murder since 1957. I've then gone on to talk about the Law Commission's description of murder, where they've said it's set upon shaky foundations and that it's a mess. And their main criticism is that different levels of criminality are not accurately graded and labelled by the law on murder. And that's primarily because a one-punch killer is treated and labelled the same as a terrorist. And the fact we have a mandatory sentence for murder exacerbates that. So my introduction, I'm starting by saying the outdated definition means that the law struggles to serve defendants, victims, society well. Notice that I'm linking back to the question here, and that is good practice. I then go on to give my definition of murder. The actus reus is the unlawful killing of a reasonable creature in being under the Queen's peace, and the mens rea is malice aforethought, express or implied. And then what I need to do is explain the actus reus, evaluating as I go, and then explain the mens rea, evaluating as I go. So I'm going to start off, as always, with the actus reus, and the first part of the actus reus is that the killing must be unlawful, not in self-defence, has to be a human being, not a fetus, can't be a brain-dead person. Straight away I'm going into some criticism here. The fact that a fetus is not a legal human is controversial, particularly to pro-lifers, but of course we need that rule to ensure that abortion can be legal in this country. We also have problems with the definition of death because surprisingly we don't actually have a certain definition of death, legally speaking. We use the BMA one where the brainstem activity ceases. That was applied in the case of Malsharek, but we can't totally rely on this definition. Be quite interesting to mention here the recent case of Alfie Evans, and sadly the dad in that case is adamant that although his brain-dead son has been classed as legally dead and therefore lawful to withdraw support, that in his dad's opinion he's still alive and switching off life support is murder. So conflict there. In other countries, they have legislation that provides a legal definition. The fact that our government won't give a legal definition means that the law still struggles to serve defendants, victims, society well. Again, link back to the question. My next part of the actus reus is to say that the killing can be a positive act or an omission if there's a duty to act. And I've got some important omissions cases listed there. Whilst it's important that we do allow murder for omissions, such as parents killing their children through starvation, omissions has posed a bit of a problem in relation to withdrawing life support machines. And of course, we've touched on that already with Alfie Evans. We know that doctors are under a duty to act for their patients through their contract, but we also know that that duty to act will come to an end. It can't go on forever. And the duty for a doctor to act ends when it's no longer in the patient's best interests. And we've seen that in the Bland case and also in Alfie Evans. And remember, the Alfie Evans case was confirmed by the European Court of Human Rights in 2018. So really recent authority on that. Criticism, of course, though, is it seems illogical, really, to classify that as an omission, and yet a positive act, which would help patients such as Pretty and Nicklinson, would be classed as murder. Morally, you might argue there's no difference between the two, because in both situations, withdrawing treatment or giving a lethal injection still results in death of the patient. And I've put there, of course, that many people believe that euthanasia should be legal. It shouldn't be categorised as murder because there's a moral difference between assisting a terminally ill person to end their life and a cold-blooded killer, such as the Moors murderers, for instance. Of course, the reason that there is this distinction is because motive is irrelevant to intention, Dudley and Stevens. But I think, and many others think, that the law on euthanasia needs to be reformed if the law on murder is to serve defendants, victims and society well. We shouldn't have this arbitrary distinction between trust and the trust case and the Pretty case. I've then gone on to causation. That's the next part of my actus reus of murder. So because murder is a result crime, we have to show that the defendant was the factual and the legal cause of death. Notice, I'm not going to write everything in the world about causation here. You could write a huge essay just on causation, but you wouldn't be picking up marks for it. So notice that I've just cited the important causation cases to show that I know it, but my focus has to be on murder. So I've used my but for cases and I've cited my cases on legal causation. What I've gone on to consider, though, is what part of causation is problematic for murder, because murder is what we're talking about here. So causation is problematic for murder where you've got a defendant supplying the victim drugs. Obviously, that's an unlawful act to supply drugs. But if the victim then chooses to self-inject, that is a novus actus interveniens which breaks the chain. And that was confirmed in the case of Kennedy. So if the victim is self-injecting, that breaks the chain, it's not murder. In the case of Evans, though, we said that if the defendant has supplied the drugs, the victim self-injects, overdoses, and the defendant runs away and doesn't contact the emergency services, that could be manslaughter. So the problem I'm drawing attention to here is that there is a debate about, there's still problems about, whether supplying drugs, being involved in drug taking can lead to murder or manslaughter convictions. Of course, in Kennedy it wasn't murder, but many have said in that case, well, that's unfair because although the defendant didn't inject it, the victim did, the defendant was still very much involved in preparing the drugs beforehand. I've dealt with the actus reus, so I'm now moving on to the mens rea of murder. So my mens rea of murder is intention to kill or intention to cause GBH, Vickers. Remember that your first bit, intention to kill, can be direct, aim, objective, purpose, that comes from Mohan, or it can be oblique intent, Nedrick, Woolin, Matthews. And you can see here by the amount of red I've got that there is a lot of evaluation you can do on the mens rea of murder. So first of all, I would say that it's very surprising to most people that you can be guilty of murder through intention to cause GBH, Vickers. Most people don't realise that if you punch someone and they bump their head and die, that's murder. Most people think that would be manslaughter. And that is illustrating the problem that the law is categorising the one-punch killer the same as a cold-blooded murderer, such as the Moors murderers. And that means we're not recognising different levels of culpability. The Law Commission has actually said that Parliament never intended for that to be the case. They believe that the present definition of murder is too wide here on the mens rea, that intention to cause GBH shouldn't really be enough for murder, and a lot of people would argue that. I've then gone on to consider criticisms of oblique intent, and of course the problems here with oblique intent is that the courts have struggled to come up with a definition and a test. The law has developed bit by bit through case law. So again, no act of Parliament here, it's just judges making the rules. And these different cases and rules can be confusing for juries. We have the Nedrick test, so that you can be guilty if death or serious injury was a virtual certainty and the defendant realised that. Well, some people argue that that shouldn't be enough for murder because foresight and intention are precisely different things, that perhaps foresight should not be enough for murder. So we've got really quite a wide definition here, thanks to the mens rea. I'm now going on to consider the fact that related to the wide mens rea is the problem that murder carries a mandatory life sentence. And this is too rigid. Essentially, you've got the same sentence for a one-punch killer. So if I punch someone and they die, I'm a murderer. If I decide to kill a load of children and bury them in the moors, I'm a murderer. Both instances, I get a life sentence. That doesn't recognise different levels of culpability. And that has been criticised, you can see I've said there, excuse me, by Smith and Hogan. This mandatory life sentence is also particularly unfair if you think about euthanasia. If somebody assists someone to end their life because they're terminally ill, even if that person is begging them to assist them, if they do it and get caught, they are a murderer, the same as a terrorist. They get the same sentence as a terrorist, although they've got good intentions, if you like. This seems really unfair, and that was highlighted in the case of Tony Nicklinson. The Law Commission have suggested a solution would be to abolish the mandatory life sentence, but the government has opposed this. I'm reaching sort of conclusion area now. So I've mentioned the Law Commission's 2006 report, I've highlighted it there. And in that report, the Law Commission proposes a new framework for the law of homicide, where you would have first degree, second degree, murder and manslaughter. And that would make the law clearer, more coherent. It arguably serves society better because you would be able to recognise different levels of culpability. Another alternative suggestion is to reform and abolish the murder-manslaughter distinction, create one single offence of homicide, and all the characteristics will be taken into account when sentencing. I don't really like that idea too much. A big problem with that is it would give the judge too much power, I think. Justice argues that the law of homicide should promote clarity, consistency, legal certainty. Looking at what we've seen in this essay, the current law doesn't do that. So definitely reforms need to occur. In Justice's opinion, they say that the definition of murder should be clarified, and I would agree with that. We need a statutory definition, and only include those who intentionally, unlawfully kill another person when they have the freedom and capacity to do so. I really like that definition, and I think that would address the law on murder and serve society better, again linking back to the question. As usual, there's your marks scheme, 15 marks for your AO2, 10 for your AO1, and you can see that this essay would achieve full marks there. Lovely balance of AO1 and AO2. Okay.